Good afternoon. Welcome to University of Houston Law Center. I'm Dean Leonard Baines. I want to welcome you to this UH Law CLE dealing with the Supreme Court update. We've been doing this for a number of years and they've been very, very popular. We had about over 800 RSVPs for this particular CLE. Before I start, I want to discuss UH Law because I know a number of you may not be UH Law alums, but UH Law is a premier law school. The students have incredible entry credentials. The last cycle, we had a median 3.72 GPA and a median 161 LSAT. 161 LSAT is the 80th percentile, which means that our students, the median of their LSAT scores is in the top 20% of test takers. We have 9 specialty programs in the top 50, including health law, which is number 7, intellectual property, which is 8, part-time program 8, trial advocacy 13, legal writing 16, and environmental law 30. We have a very talented faculty who regularly publish in the top 30 law reviews, and about 20 are members of the American Law Institute, which is the most prestigious organizations of judges, lawyers, and law professors in the country. UH Law will present a 3-part CLE series focused on these pivotal Supreme Court decisions from the 2023-2024 term. Today's broadcast is segment 1. The goal is to provide meaningful insights into the recent Supreme Court opinions. Over the past 2 years, the U.S. Supreme Court has seen just judges weighing in on major decisions that impact our society. The importance of providing knowledge about these important cases cannot be overstated. As the CLEs, they're part of our broader effort to engage with the community in providing legal information. Through the CLE, the law faculty provide accurate information and understanding of these landmark cases, and the viewers gain knowledge and insight of how these decisions affect law, society, and our lives. An educational institution is a forum providing this kind of important information by providing light, not heat, on these issues. Kicking off this series, this session will cover the First Amendment's applicability to social media companies, the Second Amendment and gun regulation, reproductive regulation, and presidential immunity, ballot eligibility, and the January 6 prosecutions. The faculty experts will include many of our top faculty, scholars, and teachers. I'm going to introduce each of them before they do their particular presentation. So the first thing I'm going to introduce is Professor Peter Salib, who will discuss First Amendment and Second Amendment issues. Professor Salib is an assistant professor of law at the University of Houston Law Center and associated faculty in public affairs. He also serves as law and policy advisor to the Center for AI Safety and is co-director of the Center for Law and AI Risk. Professor Salib is an expert in the law of artificial intelligence. His research applies substantive constitutional doctrine and economic analysis to questions of AI governance. He has previously written about how machine learning techniques can be used to solve intractable seeming problems in constitutional policy. And he's been published in a wide variety of great law reviews, including the University of Chicago, Michigan Law Review, Northwestern Law Review, and Texas Law Review. Before joining the University of Houston, he was a Klemenko Fellow and lecturer on law at Harvard Law School. And before that, Professor Salib practiced at Sidley and Austin and served as judicial clerk to the Honorable Frank H. Easterbrook. Let's welcome Professor Peter Salib.
All right. Thank you, Dean, for that very generous introduction. So I am going first in today's Supreme Court update, and it has fallen to me to talk about 2 topics that were important at the court this term. The First Amendment, and in particular, the First Amendment's applicability to social media companies. And second, the Second Amendment, and in particular, how it will shape U.S. gun regulation in the wake of the landmark case from the previous term, Bruen. So I'll talk for a little while about the First Amendment cases. I'll try and say a little bit about what happened in each of them, and point out some things that seem noteworthy or interesting to me. And then after I've made it through the First Amendment cases, I'll say something about the Second Amendment cases. We'll see if I have an hour's worth of things to say about both of those, but if not, I'll be interested to answer your questions in the Q&A at the end. On with the show, starting with the First Amendment. So this term, the Supreme Court had two cases about the First Amendment and social media. The first one is actually two cases, but both of them under the name NetChoice. And then the second one being Murthy versus Missouri. Both of those cases are essentially about what social media companies may or must feature in your Facebook feed, your Twitter feed, the sort of content they push to their users as a matter of government regulation. So beginning with NetChoice, these are the twin cases out of Texas and Florida dealing with regulations that the states of Texas and Florida had imposed on specifically how social media companies moderate their content. As you may know, social media companies have various policies about what kinds of things are and are not allowed on their platforms. They range from stuff that I think is pretty uncontroversial. So, no true threats, no threatening to murder other users and things like that, to stuff that maybe does become more controversial in certain cases. So most social media companies have policies around what they deem to be misinformation. So posts by their users that they deem to not reflect the true facts about the topic on which they were being posted. And so both Florida and Texas had imposed regulations limiting social media companies' ability to moderate their feeds, and in particular, their ability to either remove certain posts from their feeds or to sort of algorithmically derank certain posts. So as you may know, most social media feeds are not just a constant stream of whatever everyone else is posting. They're mostly mediated by ranking algorithms. The companies that provide these services are in the business of showing you content they think will engage you so that you stay on their platform longer, and they can serve you more ads as well, or maybe collect more data. And so the Texas and the Florida laws were not identical, but they were pretty similar. They were limitations on the ability of the ability of social media companies to remove or derank things. They were not necessarily hard bans on the removal or deranking of certain kinds of content. But for example, they might require a written explanation of the decision to remove a particular post. And of course, in a world where Facebook has many billions of users and is making many, many millions of content moderation choices every day, a written explanation requirement is, if not in fact a ban on removal, maybe a de facto ban. As I said, this is two cases coming from two states and indeed two circuits. The Florida case came to the court via the 11th Circuit, and the Texas case came to the court via the 5th Circuit. The 11th Circuit had, in fact, enjoined the application of the Florida law, and the 5th Circuit had not. Interestingly, the 5th Circuit had determined that the act of curating or moderating social media feeds was not an expressive act in any way of the social media companies. Thus, the First Amendment was effectively not implicated at all, and this was an easy case for opening or upholding the law, at least as far as the Fifth Circuit was concerned. The Supreme Court actually vacates and remands both decisions. So the 11th and 5th Circuit come out both ways, and the Supreme Court says, actually, both of you are wrong. And so that should be some signal that this case is not telling us anything super definitive, because the court is not either clearly saying that these laws are constitutional, nor that they're unconstitutional. In a sense, maybe this is a bit of a punt. The court vacated and remanded for further proceedings. So it doesn't tell us maybe everything we would like to know about how governments may and may not regulate social media. But nonetheless, I think there's some pretty interesting stuff in there. One of the interesting things was that the court made a big deal about the breadth of the category social media that was regulated by the Texas and the Florida laws. So, my examples so far of what counts as social media have been sort of the things that I think most people think of when they think of social media, your Facebook feed, your Twitter feed. But as the court pointed out, the law as written plausibly implicated a whole bunch of other kinds of technologies as well. So maybe Facebook's Messenger, right? The sort of ability you have to send direct messages to other users as opposed to send things out to the feed that comes through. Maybe apps like WhatsApp that are sort of a hybrid between something like a Facebook feed and something like a Messenger app. Well, you can use WhatsApp to sort of communicate one-on-one with individuals. There are also these really big WhatsApp or Slack threads that have maybe thousands of people in them that operate more like a mini Facebook feed. Even Venmo, the payments app, maybe some of you know, when you split the pizza with your friends and you send them a Venmo request for money, that request actually goes out on a public feed by default, so other people can see what you're spending money on with your friends. And so there's a question as to whether that is social media. And maybe that doesn't seem like a super interesting question, but it was important to the court's decision. In fact, I think it was one of the main reasons that the court decided to remand the case instead of simply deciding the constitutionality as a social media, because the briefs were written as if social media was basically Facebook in the way I suggested at the beginning. Not only that, the briefs, the challenge was brought as a facial challenge to the law. So this was a pre-enforcement facial challenge for reasons you can probably understand as attorneys. The lawyers for the social media companies preferred to have the law enjoined before it was actually enforced against them, rather than challenging a particular enforcement action. And so that meant they were bringing a pre-enforcement facial challenge, which the court said raised real difficulties for them, especially given this uncertainty about what the law even covered. As many of you probably know, to win a facial challenge, a facial constitutional challenge, to enjoin a law under the First Amendment, well, the court changes its formulation from case to case, but you really have to prove that the law is going to be unconstitutional in a lot of applications. In this case, it said in most of its applications. In some other cases, the court will say that you have to show that it would be unconstitutional in essentially all of its applications. And so the court remanded to the 11th and 5th Circuits in part to determine how and whether this law applies to your Venmo feed and your WhatsApp feed and maybe your iPhone Messages app, and whether those applications would also be unconstitutional. So that's a little bit of a punt, but nonetheless, before the court punts, it tells us some things that I think are important. First of all, it tells us that the Fifth Circuit is simply wrong in its blanket holding that content moderation on social media sites is not expressive and thus does not implicate the First Amendment in any way. Now, maybe that is surprising to some people. Maybe it shouldn't be that surprising, though, for people who are aware of the court's prior case law on publishing and content adoption and moderation more generally. So there are some cases that I think seem totally obvious as cases where the First Amendment does apply. There are many newspapers and magazines that solicit, say, letters to the editor, and they exercise their discretion in deciding which of those letters to publish. And we have all long understood those exercises of editorial discretion to be protected expressive activity under the First Amendment. But it's not just newspapers, actually. We have seen cases about cable TV providers, for example. Your cable provider, which has hundreds of channels, putting out thousands of different television shows. And when the government has attempted to regulate what does and doesn't appear on those cable channels, the Supreme Court has held that the cable companies do have at least a colorable First Amendment claim. That doesn't mean they win, but the First Amendment does apply, even in those cases where the cable company is basically just, providing a tube for the data to flow through to people's homes. The court has said it has enough of an expressive interest, at least to be able to object to being forced to carry content with which it doesn't agree. And so it's maybe not so surprising that the Supreme Court would say that the Fifth Circuit's blanket approach that said no First Amendment analysis whatsoever, easy case, was wrong. Now, the fact that you know the First Amendment applies doesn't tell you the answer to the case, and it doesn't even tell you how to analyze the case. So you might ask, well, given that the First Amendment applies to this kind of expressive activity, well, what's the standard? What test are we going to apply to see if this law is constitutional? Maybe we're going to apply strict scrutiny. Maybe we're going to apply intermediate scrutiny. Maybe it's some other First Amendment test. There are lots of them. And the Supreme Court does not tell us the answer to that question in NetChoice. In those previous cases that I mentioned, other cases involving regulation of publishing and other content hosting entities, discretion to choose to publish or not publish various kinds of media, the court has actually not always applied the same test. There are cases where it's applied something like strict scrutiny and sort of presumptively thought of the regulations as being more constitutionally suspect. But in a case called Turner versus FCC, a case about Turner Broadcast, a cable company, the court, in fact, explicitly declined to apply strict scrutiny and applied something more like intermediate scrutiny, where the law is, I think, much more likely to survive. And so, we could ask, well, why the difference between those cases, and how should we expect those differences to cash out in terms of a case like NetChoice, a case where the government is regulating social media companies' content moderation. Well, one thing to ask about is, even if we think that all of these companies are engaging in some kind of expressive activity when they decide what content to publish or host or transmit, we can ask, well, how expressive is it, and how much of an interference with the company's expression is it when they are either forbidden from or forced to host particular content. And one way to think of that is like, well, how much discretion are they really exercising when they choose to host or not host a certain bit of media. So on the extreme end of like a lot of discretion, you might think that we have entities like the New York Times. It's very difficult to get your work published in the New York Times, as I, who's sometimes writes and pitches op-ed letters, knows. They really don't want almost any of the stuff that's out there, and the stuff that they do want, they're very selective about. They think about whether it fits with the New York Times brand, New York Times goals in terms of transmitting the news. And indeed, once they agree to publish something like an op-ed, it goes through an editorial process with the New York Times, such that when it comes out, like maybe even some of the words in the letter will have been written by someone at the New York Times. As a consequence of that, I think that we as consumers of the New York Times are apt to attribute the stuff in the news stories or the op-eds to the New York Times as an entity, in addition to attributing them to the individual journalists and opinion writers as individuals. I think it's coherent to speak of the New York Times as having a point of view, for example, or the New York Times being interested in certain topics. And so maybe that's one reason to think that when we regulate the New York Times's ability to choose what it puts in its newspaper on its website, that should be subject to pretty exacting First Amendment review. By contrast, a cable company doesn't really do that, right? A cable company probably does some review of the channels that it hosts. Cable companies, I think in general, are, for example, reluctant to host, at least as a matter of their basic packages, channels that have explicit content. Maybe explicit content during the daytime is especially looked down on. So they are making some discretionary choice, but it's not as if Comcast or Turner in the Turner case is reviewing episodes or even individual programs. It's not like the cable company decides if ABC is going to renew Parks and Recreation for a 5th season or whatever. And so insofar as the companies are investing less editorial thought about the particular content that is going out on their platforms, maybe we think that there's less of an expressive harm when they are either forced to or prohibited from hosting particular content. And one thing that is highlighted in the Barrett concurrence in the NetChoice cases is we just don't really know from the briefing so far in the NetChoice cases exactly how this works at companies like Facebook, much less the sort of secondary social media companies that weren't really discussed at all. So you could imagine a wide range of things that the Facebook algorithm is doing. At one end of the spectrum, you can imagine that it is simply filtering for, say, explicit content, right? If Facebook doesn't want to have nudity on its website, it doesn't have to, and it could be automatically kicking out all nudity. That would be, I think, sort of closer to what a cable company does, and maybe even less particular than what a cable company does. On the other hand, you could imagine, I don't think this is probably what's going on, but you could imagine that Facebook had an algorithm that said, well, every time someone posts the post, Mark Zuckerberg is great, that ends up on the front page of everyone's news feed. And that would be, I think, a little bit more like what the New York Times does. It's not just that they're filtering out some particular unwanted attributes that are only even tangentially related to the idea being expressed. That's a case where where they have picked a particular idea and indeed a particular set of words that they want to highlight, and they're putting that on the front page. And those might be quite different. So the more what Facebook is doing is like the former thing, the more I think we should expect strict scrutiny to apply to laws like this. And the more it seems like the latter thing, the other way around. The more it seems like the former thing, the more we should expect a lower tier of scrutiny, something like intermediate scrutiny to apply. And the more it seems like the former thing, where they're really like thinking about, a particular message that they are reviewing and putting on the top of their algorithm, then maybe we think strict scrutiny should apply. By the way, I think, once we dig into this, it's much more likely that content moderation at scale is doing the kind of thing that cable companies do than the kind of thing that the New York Times does. A final interesting thing about the case. So I said before that the Supreme Court said Texas was totally wrong the Fifth Circuit was totally wrong about the First Amendment not applying at all. Another thing that seemed totally wrong, according to the Supreme Court, was Texas's justification for the law. So as the Supreme Court puts in its majority opinion, the state of Texas was very forthright about the reason for implementing these restrictions on content moderation. It was their view that conservative points of view were being differentially disfavored, and that Texas was hoping to equalize the balance between conservative and liberal points of view on platforms like Facebook. And the Supreme Court says here, as it's said in many other cases, that equalizing points of view is never a legitimate interest of the government. One of the most famous places where the court said this was Citizens United, a case where it was, I think, in the aftermath, liberal commenters who were most outraged about the Supreme Court's rejection of equalizing different voices in the public sphere. So the Supreme Court says this again. It says that Texas's stated justification for the law is categorically constitutionally insufficient. And one thing that's interesting about that to me is then it makes me wonder, well, then why remand as to the Texas law? Maybe the Florida law, there's more questions to answer about Florida's reason for the law. But if Texas has simply said, we have a justification for this law, it's an unconstitutional one, well, shouldn't that just be the end of the case? So I'll be interested to see what happens on remand. Maybe the court is giving Texas another chance to think of a better justification. I don't think it's the kind of thing we normally do in litigation. We sort of make parties stick to their litigating positions. And maybe that's what will happen below. So I think there'll be a lot of interesting questions about judicial estoppel and the law of the case, and frankly, whether the state of Texas can come up with something that's a new justification that doesn't just make them look silly for having said the other thing before. Okay, so those are my thoughts on the NetChoice cases. I guess I've only got a few minutes to talk about Murthy versus Missouri, but I think that's okay because I think in some ways it's an even less interesting case. Murthy is the case that arose when, during the height of the COVID-19 pandemic, senior White House officials were doing things like calling and emailing Facebook executives, telling them that Facebook needed to do a better job of combating things like COVID misinformation on their platform. And this raises a very similar question to the NetChoice question. In NetChoice, the question was sort of, is the social media company allowed to delete certain posts or de-emphasize certain posts? This is like or sort of allowed, is the government allowed to force these let me put it this way. In NetChoice, the question was, may the government regulate to prevent content takedowns? Murthy asked the question, may the government regulate to mandate content takedowns? Stuff that the Biden administration thought was COVID misinformation. Now, this case gets dismissed on standing grounds, so we don't get a lot of information on the merits. The standing problem was that the plaintiffs are not, in fact, the social media companies in this case. In the NetChoice cases, they are via via an industry association. But here, the plaintiffs are basically users of the platforms who claim that they were censored. So they posted some say COVID vaccine skeptical views, which were then taken down. And they argue that the reason that they were taken down were because the White House officials had pressured Facebook to take down more of those kinds of posts. This raises two kinds of standing problems. One is a kind of a mootness problem. The COVID pandemic is at least not at its height anymore, and I don't think there was evidence in the case that White House officials were continuing to pressure social media companies to do stuff around perceived COVID misinformation. So that's a kind of mootness problem. They're asking only for prospective injunctive relief, and it's not clear that they have a prospective injury. The second is a traceability problem. There's a question as to whether, insofar as these plaintiffs' posts were taken down, which indeed they were, there's a question whether that was because of the White House's actions at all. Because after all, as we discussed at length already, social media companies have extensive content moderation policies. Facebook, Twitter, and other companies include in their policies, and have included in their policies for a long time, that they try to take down posts that they perceive as inaccurate or misinformation. And so it's totally possible that the things that these users posted would have been taken down, even had the White House not ever emailed Facebook executives about COVID information on their platforms. So those are the standing problems in that case, and that's how the case gets decided. We could ask interesting questions about the standing problems, like, well, why wasn't it the social media companies who sued in this case? We saw in NetChoice that they certainly do know how to sue the government if they feel the government is interfering with their preferred content moderation policies. And so if the social media companies were so upset about the request from the Biden administration, well, you might think that they would have sued. That's maybe more evidence for the traceability problem in the standing analysis, right? If this was a big deviation, if this caused a big deviation from the social media companies' preferred content moderation policies, well, then maybe they would have sued, which suggests that maybe whatever policy that caused the plaintiffs' posts to get taken down was not so far off from the one that would have been in place without the White House interference. Now, the merits of this case, I think, are also quite interesting. We don't learn much about what the law says about the merits. One thing that's interesting about them is there doesn't seem to be much disagreement factually in the majority and the dissent about what actually happened. A number of the emails between the White House and Facebook executives are in the record, and so we know what the administration said. And indeed, the Biden administration was saying to Facebook executives that the administration felt that Facebook was allowing too much COVID misinformation to be on the platform. It was asking Facebook to control the flow of that information, to take down those posts, to de-emphasize them. And it's an interesting question whether, if there were not a standing problem in this case, that would be a First Amendment problem. A big difference between this case and NetChoice is a case about a statute with penalties. And this is just a case about a politician, and a person in office, calling some of their constituents and asking them in maybe an aggressive way to say something differently. Now, I suspect that this happens kind of all the time in traditional media when, the New York Times says mean things about the president. I suspect often the president and the president's chief of communication calls somebody at the New York Times and says, this is a totally unfair attack. You need to stop it with this stuff. And in fact, it's not even true what you've written. And I think in most cases, we don't think of that as a First Amendment problem. Now, in one of the emails, the White House says that they haven't taken the possibility of regulation off the table, and so maybe that's a threat with more force, and maybe that's what takes us from just being an aggressive request to a potential government interference with free expression. It's not obviously true that that's right either. In other First Amendment contexts, when we're asking about threats, usually whether you know, citizens can be punished um, for threatening others, we say, well, it's not really a threat if the thing you're threatening to do is something that you're legally entitled to do. So the famous case about this is a case where a union leader threatens to go on strike unless a government actor does something that the union leader decides. And going on strike is and was at the time protected by law. The Supreme Court holds, well, that's not a threat. That's just a bargain or something like that. It's two parties taking maneuvers that the law allows them to take. So, insofar as the executive branch is entitled to regulate social media and maybe to regulate them to prevent false speech, which the First Amendment does allow some scope for. It's not obvious that it's a First Amendment problem for the government to say, do this thing voluntarily, or we'll make you do it by law in a way that we're entitled to. Now, you can imagine that instead the Biden White House is saying, do what we want, or we'll like throw you in prison without bringing charges, act in a totally unlawful way. Well, then, of course, yes, that would seem like a threat. And you can imagine things in between where the White House is threatening some sort of onerous and colorable, but ultimately not that plausible litigation unless Facebook starts taking down more COVID misinformation. And that would be a harder case, but it's not obvious that's what was going on here. And we may never know what the answers to questions like that, at least not from this case, because the plaintiffs here have no standing, and it's not obvious that the plaintiffs who would have standing, the social media companies, have any interest in bringing these cases. Okay, so I think that is most of what I wanted to cover about the First Amendment cases. So on to the next amendment, the Second Amendment. So there we have two important cases from this term, U.S. versus Rahimi, which is a constitutional case about the legality of restrictions on people who are subject to domestic violence restraining orders being prohibited from owning firearms. The other case, I said the Second Amendment, is not actually a Second Amendment case. The second case is Garland versus Cargill, which is the case adjudicating the legality of the federal ban on bump stocks as a kind of machine gun. And that's just a question about statutory text. There is a machine gun ban, and the question is whether a bump stock is a machine gun. All right, so I'll start with Rahimi. Rahimi is a really important case and a highly anticipated case because it's the first Supreme Court case on the meaning of the Second Amendment since the court decided Bruen. Has it been 2 terms since Bruen now? I think it's been 2 terms since Bruen now. And Bruen was a case where the court sort of threw out all of the stuff that the lower courts had been doing in Second Amendment litigation since the court had decided Heller and McDonald, where it first held that there was an individual right to bear firearms. So after Heller and McDonald, the lower courts had essentially imported a kind of First Amendment style framework to dealing with restrictions on the possession of firearms. It asked about certain features of the law restricting firearms in terms of how onerous it was on the right to defend oneself. And depending on the answers to those kinds of questions, applied either strict or intermediate scrutiny, usually intermediate scrutiny. Intermediate scrutiny is kind of like a means-end structured test. You ask what the government's goal is, whether it's a legitimate goal, and if it is a legitimate goal, you ask if the law is at least relatively well tailored to that goal. That is, the things the law forbids are in general the things that you would forbid if you were trying to serve that goal. That is, the law is neither super over-inclusive nor substantially under-inclusive. Bruen said, no, we're not going to do any of that scrutiny stuff. It said, in fact, no means-end scrutiny should be a part of Second Amendment analysis. Bruen said that instead we needed to look exclusively to the history, tradition, and meaning of the constitutional text. And at least if you read Bruen on its face, it seems to suggest that the way you decide a Second Amendment case is you look at the modern law restricting access to firearms. You go look at the historical record of firearms regulation around the time of the founding. And if you can find a regulation of firearms that looks really pretty close to identical to the law that the court is reviewing, well, then that law is constitutional. And if you can't find one that's a really close analog, a very near twin, well, then the new law is unconstitutional too. The logic of that reasoning is supposed to be something like, something like the following. Justice Thomas said in the Bruen opinion, well, the founders had many of the same problems we have today. They had violence, they had homicide, and they had violence with guns. And so if in the founding era, the founders were faced with a similar problem to what we have today, and they didn't enact a certain kind of regulation to solve that problem, well, that's evidence they thought that kind of regulation was unconstitutional, because if they thought it was constitutional, well, then they would have enacted it. We can talk in the Q&A about whether that makes sense even on its own terms, but that was, I think, supposed to be part of the logic behind this historical analog approach to discovering or to adjudicating Second Amendment cases. So in light of Rahimi, which was thought to be a quite pro-gun case and quite pro Second Amendment turn in the court's jurisprudence, I think a lot of people thought Rahimi was going to overturn this conviction and say that that it was not constitutional to disarm people during the course of their subjection to domestic violence restraining orders. But in fact, the court did the opposite. The court upheld Mr. Rahimi's conviction and said that, in fact, governments are allowed to disarm people who are subject to domestic violence restraining orders. And it did so on a basis that did not look very much like that, at least that very literal reading of Bruen that I just gave you. Because among other things, there was no such thing as a domestic violence restraining order at the founding. Violence against women was much less criminalized than it is today. And so the historical analogs for a law like this were not so close. The federal government rested its disarmament law on two kinds of historical analogs. One was these things called surety laws, where at the founding, persons who were adjudged to be potentially dangerous could be forced to pay a surety, a kind of bond, which they would then forfeit if they acted in violent ways. And then also these going armed laws that would penalize people who would go armed, meaning not just carry arms around, but brandish them and threaten them. And this was punishable at the time, including by disarmament. Those in many ways do not look very much like the law at issue in Rahimi. They have nothing to do with domestic violence. They have nothing to do with restraining orders. What they do have in common is that they are disarming individual people based on an individual determination that those people are too dangerous to carry firearms. Now, maybe you think, well, this individual determination is kind of the sine qua non of disarmament, the thing that makes the modern ban that applied to Mr. Rahimi analogous to these historical surety and going armed laws. The court says, in fact, no, it's not necessary to have an individualized determination of dangerous in every case where a modern legislator wants to disarm people who it deems to be dangerous. It says there might be categories of people who you can disarm as well, even without making a kind of individualized determination of the kind that precedes a domestic violence restraining order. I mentioned before that Bruen had said that means and scrutiny was not the stuff of Second Amendment analysis. The majority opinion in Rahimi says something that sounds quite different. I'll just read you a quote. This is a quote about the inquiry of historical analysis, like how we know whether a modern law is sufficiently similar to historical regulations to render it constitutional. So the court says, quote, why and how the regulation burdens the right are central to this inquiry. For example, if laws at the founding regulated firearm use to address particular problems, there will be a strong indicator that contemporary laws imposing similar restrictions for similar reasons fall within a permissible category. Even when a law regulates arms bearing for a permissible reason, though, it may not be compatible if the right does so to extent beyond what was done at the founding. And look, maybe that's not means ends analysis, because it starts by looking at historical ends and historical means instead of just the means and ends that the lawmakers today wanted to employ. But it seems pretty means endsy to me. Looking forward, then, I think what we're going to see is a lot more sort of means ends analysis of this kind. And the question is going to be whether we can anchor those means and ends to the means and ends of the past. And anchoring them to the means and ends of the past, it's pretty clear from Rahimi, is not going to mean finding a law that looks identical to the one today. And it's not even going to be finding a law that responds to a problem that is identical to the one today. Again, in the past, these going armed laws, these surety laws, were, I think, mostly worried about fighting in public and sort of like, brawling. And domestic violence, I think, is an important, but also importantly distinct concern. And the court here says that, look, those are similar enough. The question is dangerousness. And in some sense, you might say, well, all firearms regulations are, or maybe at least should be, about dangerousness. So understanding how generally to define these historical concerns that legislatures are trying to address, the more general, the more modern laws are going to be permissible, and the more specific, the less modern laws are going to be permissible. And then, how generally to define the means, right? A surety really does not look very much like disarmament in the course of a domestic violence order at all. Like, one literally involves a bond and one doesn't. And so here again, I think Rahimi is a case that's opening up First Amendment analysis to consider, I think, as potentially constitutional many more laws than seemed to be the case after Bruen. By the way, the author of the Bruen opinion agrees with that. Clarence Thomas wrote the majority opinion in Bruen, the one that seemed quite pro-gun, quite anti-regulation, and Justice Thomas has a dissent now in Rahimi saying that the majority is now doing it all wrong. Okay. I guess the final thing to say about Rahimi is many worried that if Rahimi's conviction was overturned, that it would throw federal criminal law and state criminal law into disarray. Um, um, there are many provisions of law that disarm people for having committed various other crimes or being subject to certain other kinds of criminal or quasi-criminal orders. And so we at the very least know that if you're subject to a domestic violence order, you can be disarmed. I think that probably means that if you've been convicted of, say, a violent felony, then you can be presumptively disarmed for the same kinds of reasons. But you might then wonder, well, what about laws that disarm people who have been convicted of felonies that are not violent? So if you've been convicted of felony fraud, what if there are provisions that, what about a provision that was sort of a 3 strikes rule for felony convictions that disarmed you? So if there was proof that you were not law-abiding, but not proof that you were violent, how would that figure into a Rahimi-style analysis? And then there's another question that will be interesting going forward. So you could wonder about gun restrictions based on other reasons than the person's dangerousness, where dangerous means something like propensity to commit violent acts. So Heller, for example, the case that originally recognized the individual First Amendment right, said that it was clearly constitutional for governments to disarm people who had certain mental illnesses, maybe people with certain kinds of extreme delusional disorders who don't know what's real and what's not. And it's not so much because we think of them as being violent, but it's because we think of them as not having the right capacities to discern when gun use would be appropriate and not. It's not clear that there were laws like that at the founding, or at least it's not clear from the briefing in this case. And so it'll be interesting to see in the future what the court says about laws with those different kinds of justifications and how they map on to the regulatory justifications of the founding. Okay, last case, and then someone else can talk for a while. Last case is Garland versus Cargill. This is, as I mentioned before, the bump stock case. As people may know, a bump stock is a piece of equipment that allows a gun user to use a gun that would not otherwise be able to fire rapidly, in sort of the way that we think of automatic or machine guns as firing. So a bump stock is the kind of thing that could take a semi-automatic rifle, a rifle for which you have to pull the trigger 1 time per shot, and allow it to fire very quickly, maybe hundreds of rounds per minute. A bump stock was I think famously used in the Las Vegas shooting several years ago to pretty devastating effect, and indeed that may have been the precipitating event causing the agency to update its regulations to include bump stock enabled guns in the definition of machine gun, which were then banned under the federal machine gun ban. And so this is quite a narrow decision again. It is a quite textualist decision. Well, actually, before I read the text, I guess I should just be really clear on how a bump stock works. At least to my understanding, I don't own one and have never used one. But my understanding is that the idea of the bump stock is it is enabling a rifle, when you fire it, has a recoil. That is, it is propelled backwards as the bullet is propelled forwards, And a bump stock is an add-on that essentially allows the gun to sort of spring back forward after its recoil. So it comes back and then it bumps forward. And in bumping forward, it allows the gun to sort of press itself against the finger such that the finger actuates the trigger another time, causing the gun to fire again, to recoil back, to bump forward, and to sort of oscillate in this way, such that many rounds can be fired in a short period of time. So the statutory definition of machine gun in the federal machine gun ban is as follows. Quote, the term machine gun means any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. And then there's some more stuff, but I think that last phrase is the most important one for the decision, by a single function of the trigger. And so the majority says a bump stock, a gun with a bump stock is not a machine gun because it doesn't fire more than once with a single function of the trigger. As I just described, the way the bump stock works is the user pulls the trigger one time, the gun bounces towards the user's body and then back, and that causes the trigger to be pressed again, triggering another round to be shot, and so on. And so the trigger mechanism, the little lever that comes out of the body of the weapon that causes the round to be fired, is being depressed over and over and over as the bump stock bounces the gun forward and backward. This is what the majority says. This is the main, I think, thrust of the holding. It serves as a secondary thing, which is that the statute requires the machine gun to have repeat fire, quote, automatically. And they say, well, a bump stock's not really automatic because in addition to holding your sort of finger in one place, you have to sort of keep forward pressure on the gun. And so the human body is doing kind of some other work too. I'm not sure that's super convincing to me. The first point about single function of the trigger seems like a better textual argument. The dissent says, what are you guys talking about? The whole point of a bump stock is to make a non-machine gun function like a machine gun, to fire a bunch of rounds without the person using it having to move their finger a bunch of times. And they say, you know, when you fire bump stock and you fire a bunch of rounds, you are actuating the dissent says a, quote, single pull of the trigger. And that's sufficient to bring the bump stock within the statutory meaning. There's some plausibility to that. Certainly as a point about statutory intent, I think there's a lot of logic to that. However, I don't know, when I read the statute says single function of the trigger, not single pull of the trigger. And, you know, I think on the text, there is some plausibility in the view that the trigger is functioning over and over when a bump stock is being used. So maybe the majority has the better argument textually. And indeed, like, maybe we shouldn't be surprised about this, because we could ask the question, well, like, why do bump stocks exist in the first place? Like, wouldn't it be much nicer if you wanted a gun that fired a lot of rounds to have one that you didn't have to sort of hold against your body in this weird way and have it jiggling back and forth? Wouldn't it be much better to just have automatic enabled firing? And the answer is, well, of course, an actual machine gun conversion, an actual conversion where you squeeze the trigger and hold it, and it fires many times, is clearly banned. So a bump stock is in some sense a a device specifically designed to evade the statutory text. And so in that sense, I don't think we should find it super surprising when it in fact does fall outside the statutory text. Well, and that raises all kinds of higher order questions about whether we should be textualists in cases like this, where parties seem to be really quite clearly maneuvering to evade the law's text, and thereby thwart its purpose. This is a case where maybe you could see the wisdom of pulling away from pure textualism. But of course, there are cases in other contexts where we might have the opposite intuition. Okay, I think that is all I'm going to say. I think maybe I have a few minutes left, but I don't want to drag on about these cases. We've got a number of interesting stuff to hear from others, so I will leave it there for now. And thank you all for having me, and I'll look forward to reappearing on your screen shortly and answering any questions that you may have.
Thank you so much, Professor Salib, for providing such helpful and useful information and doing 4 cases. We really appreciate all your efforts with respect to that and your incredible expertise in the Constitution. So next, we're going to look at reproductive regulation. And I'm glad to introduce our colleague, Seth Chandler, who's a Law Foundation Professor of Law. He specializes in constitutional law and the application of mathematics and computer science to law. He's won prestigious university-wide Teaching Excellence Award in 1995, was a first-year winner of the Innovator Award for Wolfram Research, received the President's Medal from Loyola University for his extraordinary service in the aftermath of Hurricane Katrina, has been called on twice to testify before Congress on the Affordable Care Act. He has a broad internet presence, including a YouTube channel for his course Analytic Methods for Lawyers. He's a former associate at Munger, Tolles, and Olson in Los Angeles, and Williams Conley in Washington, D.C., before beginning his academic career. And at the University of Houston Law Center, he teaches constitutional law, insurance law, analytic methods for lawyers, and other courses. And he's become known as a real expert on reproductive regulation, especially in Texas. So he's going to help walk us through the most recent cases in the Supreme Court dealing with these issues. So let's welcome Professor Seth Chandler.
Well, hi, folks. I am going to share screen since I don't know how to function without a PowerPoint, but we need to share the right screen. Okay, hold on a second. We're sharing this screen. Okay, and I'm going to press the presentation button, and okay, we have to push that button. All right. So hopefully you can see me and hear me, and let's talk about the abortion cases of the Supreme Court last term. And like the other speakers, the views here are my own and do not necessarily reflect those of the University of Houston. All right, so I've only got 2 cases really to talk about. One is FDA versus Alliance for Hippocratic Medicine, and the other is Moyle versus United States. And for those of you who don't want to listen to every word, I can tell you that you're safe to do so, because the short version of what I'm going to say is that nothing happened. The Supreme Court basically said very, very little about the substance of abortion law this past term. But still, I am so talented that I am going to manage to fill 30 minutes with interesting information on how they came to the conclusion that they weren't going to say anything, which perhaps does shed light on things. So the 2 cases are our post-Dobbs regulatory world, in which abortion regulation is subject to a rational basis test rather than the Roe-Casey undue burden test. And they both deal with important issues in the never-ending fight over reproductive regulation. The Alliance for Hippocratic Medicine case is about the pill, about mifepristone, formerly known as RU486, and it's about the FDA's decision during the Biden administration, and before that actually, to expand the number of occasions, the circumstances under which women would have access to the abortion pill. And the Supreme Court decided that the Alliance for Hippocratic Medicine and the individual plaintiffs in that case did not have standing to challenge it. And so they said nothing about medication abortion, although they did have some interesting things to say about standing. The second case is Moyle versus United States, and that is about preemption. It is about the extent to which states can prohibit abortions in circumstances in which the federal law, the EMTALA law, seems to require hospitals and doctors to perform them. And there, the Supreme Court had swooped down and taken a case from the district court while the appellate court was sort of mulling it and decided, oh, we want to decide this case. And then it ruled that, you know, we made a mistake. We shouldn't have taken the case. And so the district court's decision that the Idaho law was preempted remains in place for now. But in the course of reaching this determination, there are concurrences and dissents that are of interest. So let's take each of the cases. And I think the central fact, the reason I'm going to put the Alliance for Hippocratic Medicine case first is because I think that as a practical matter concerning reproductive regulation, it is the more important of the two. Not that the other one isn't important as well, but this is not the world of Roe versus Wade or even the world of Planned Parenthood versus Casey, in which most abortions are surgical abortions. We're living in a world in which the majority of abortions are medication abortions. And therefore, decisions about how the federal government or state government regulate medication abortions turn out to be of immense practical importance. You can see here that the majority of abortions, at least so far as we can figure out, are medication abortions. And this, by the way, is before states were permitted to tighten up on surgical abortions in a post-Dobbs world. So I suspect that the percentage is in fact considerably higher today. All right, so just to be clear, again, why is this an important case? It's because, well, now in the post-Dobbs world, states are free to regulate abortion somewhat the way they regulate most things, that is subject to a rational basis test. There's no longer this elevated undue burden test that previously had restricted the states. And so many states might like to find ways to prevent this sort of loophole of medication abortion from what they regard, or at least many people in those states regard, as essentially morally equivalent of murdering babies. So you've seen a number of methods that the anti-abortion movement has tried to use to sort of secure what they thought was the victory in Dobbs. One is state statutes that further restrict abortion or may further restrict medication abortion in particular. A second, which is what the Alliance for Hippocratic Medicine case is about, is an attack on the FDA's approval of these medicines, saying that they shouldn't have approved them. And then the third is there is actually a federal statute, which many people read as prohibiting interstate mailing or use of delivery companies to deliver abortifacients. That's the Federal Comstock Act, enacted in 1873, and they want that act to be enforced by the federal government literally and vigorously, rather than the very basically non-enforcement of that act in recent years and interpreting it in a way where it's very unlikely that anyone ever would be prosecuted. All right, so I do think it's a case where it's important to understand the facts here. And the US standard protocol for a medication abortion is to use two drugs in a particular sequence. The first drug is mifepristone, also called RU486, formerly called RU486. And what it does is it operates to block a hormone that is needed to continue the pregnancy. The decidua of the uterus breaks down, the fetus doesn't receive nutrients or supports, and without that, the fetus perishes. And the FDA approved RU486 mifepristone, as an abortifacient, although turns out that the drug has other uses, such as treatment of endometriosis. And so the fact that you're using mifepristone does not mean that you're necessarily having an abortion, although it's quite likely that you are. The second drug that's used in the United States is misoprostol, and that's used to help the woman expel the basically dead fetus that exists. And that drug was actually approved by the FDA for things other than abortion. It was approved for ulcers, incomplete miscarriages. That is, the woman didn't particularly want to have an abortion, but very sadly, they had a miscarriage. The fetal tissue hasn't been expelled properly. That's not safe, and so you want to get rid of it. As it turns out, in Europe, this is not the protocol. They generally use misoprostol alone, but in the United States, the thought is that that is less safe and efficacious than this two-drug regimen. This case is not about misoprostol, because misoprostol, it's a lot tougher to challenge the FDA's approval, because no one really claims that, hey, it doesn't work on ulcers or it's unsafe for ulcers. Instead, it's about the FDA's original approval of mifepristone, and about the subsequent expansion of the circumstances under which that drug could be used. So let's look at some of those changes in the circumstances. When it was originally approved back in 2000, the woman could take it only up to 7 weeks of pregnancy. It required 3 visits to the doctor to do this sequence of drugs. Only doctors could prescribe it, and they sort of had to watch you take it. There was a certain dosage that was required, and doctors were required to report all adverse reactions to the manufacturer, Danco, and to the FDA. All right, so that changes in 2016, and then there's another change in 2019, but I'm just going to package those up, in which the FDA says, well, it looks like it's safe up to 10 weeks. So you can take it during this 3-week period. And as a practical matter, some people might initially think 7 weeks, 10 weeks, what's the big deal? But the big deal is that's when a lot of women sort of discover that they're pregnant and have some time to reflect on whether they want to continue the pregnancy. Second, the burdens associated with going through the medication protocol will reduce. Only 1 visit is required for the taking of the mifepristone. You don't have to be physically present for the misoprostol. In theory, non-doctors could prescribe. There's some question, I think, as to whether that really happened very often. And now the reporting requirements diminish to only having to report deaths. The Biden administration's change during the COVID period was to reduce the number of visits to 0, which meant that basically you could mail order mifepristone, and that has most likely significantly expanded its usage. It makes it more private, it makes it easier, it makes it cheaper. And so if you're an anti-abortion person, you didn't like the original approval, and now you really dislike these expansions. All right, so who are the plaintiffs? The plaintiffs are individual anti-abortion doctors and an organization of organizations of anti-abortion doctors. And where else would you sue if you were against abortion? You would go to the Northern District of Texas, because there you are very, very, very likely to get a very conservative judge, Judge Kaczmarek, who in fact you did get, and hope for the best. So they try to challenge, the plaintiffs challenge the original approval of mifepristone, the 2019 reduction in the dosage, and I think most importantly for them, the 2021 relaxation of requirements, most prominently this notion that you don't have to go to the doctor, you can get it by mail order, which as a practical matter is really, really important. And they run immediately into 2 issues before we ever get to the merits. One is, how exactly are you hurt by this Alliance for Hippocratic Medicine? This sounds an awful lot like an ideological objection to us. And the second is sort of a matter of administrative and FDA law, which is, do we really want people reaching back 20 years and challenging approvals of medications? And how much should the courts get involved in policing the expertise of the FDA in medication approval? So that there's this component of the Alliance for Hippocratic Medicine case, which goes beyond it being just an abortion case. Abortion is the setting, but it's a challenge to the notion of administrative expertise, which is obviously a central theme of this past term and for many years. All right, so little refresher on standing here. In order to have standing to bring suit in federal court under Article 3, cases like Lujan have held that there are 3 requirements. You've got to show that you, not somebody else, but you have suffered or will likely suffer an injury in fact, something that the law recognizes as an injury, not just that, gosh, you wish the law were otherwise. The second is you've got to show that your injury was caused by the defendant, not by somebody else, but by the actual person you're suing. And third, you've got to show that the court is capable of redressing at least a substantial chunk of that wrong through relief, on telling the defendant, hey, do something different, pay damages, whatever. In further cases, such as Clapper, in an older case, Simon versus Eastern Kentucky Welfare, the court went through sort of, well, how imminent must the injury be? And the court has said it must be actual or imminent, not speculative, meaning it has to have already occurred or be likely to occur soon. And here we have this issue that the plaintiff is unregulated. No one is forcing the Alliance for Hippocratic Medicine to do anything, okay? And so they have a tougher argument than perhaps your run-of-the-mill plaintiff to show that they have standing. And the court has said in prior cases, you can't rely on speculation about things that other people might do, like maybe if the government would cut down on its permissibility of using mifepristone, then maybe there'd be fewer abortions. Anyway, you've got to show that the government would take action that would induce a third party to do predictably something that would make your life better in a way that the law recognizes. All right, so how did this even get forward as it did in this case? And the individual plaintiffs argued that, look, if you loosen the regulations on mifepristone, we believe we can show that mifepristone is in fact dangerous. And that will lead to more emergencies and more visits to emergency rooms or more visits to us. And some of the time we're going to have to clean up the mess that's left by mifepristone. And we might even have to perform an abortion, which we don't really want to do. And besides, we've got other patients that we're treating. And now we've got to divert our resources to treating the carnage that is wreaked by mifepristone. That's their argument, okay? The organizations, okay, well, maybe that's okay for individuals. How do the organizations have standing? And they have 3 theories. One is associational standing, which is sort of kind of like a class action where you say that one of our members has been hurt and it makes sense for us to sue essentially on their behalf. Another is organizational standing, which is that our organization is itself hurt by the law that's been enacted or the regulation that's been interpreted. And the third is we should stand in the shoes essentially of these other doctors. After all, you've let doctors sue in other reproductive rights cases, such as Griswold versus Connecticut. Why can't we do the same thing here? All right. And the lower courts buy this. Judge Kaczmarek says that, there are a lot of emergency room doctors who are out in these rural areas. They're in healthcare deserts. It's not a matter where if someone comes in after taking mifepristone and it didn't work out well, and now they need a surgical abortion, that you could just stand aside and let somebody else do it because there may be nobody else. So the loosening means that you might have to take actions that really are offensive to you. And after all, if abortionists can have third party standing to represent their patients, why can't anti-abortionists? The district court also bought the argument that, this loosening of regulation about mifepristone and the refusal of the FDA to require reporting of adverse events other than fatalities means that the organization has to spend more time than it otherwise would telling people about how terrible mifepristone is, and that's costly. And if only the government would go back and either ban mifepristone altogether or at least get it back to that 7-week thing, our lives would be better. And the district court says, yeah, we agree. And then it goes on to deal with the statute. The Fifth Circuit essentially says the same thing. They note that there had been this argument that actually federal law doesn't require people to perform abortions, and therefore this injury is somewhat a fantasy. And the Fifth Circuit says, well, actually the Department of Health and Human Services sent out a document about obligations to perform abortions, and it doesn't explicitly recapitulate the conscience exception, and so that's enough. So both the district court and the Fifth Circuit panel found there to be standing. The Supreme Court, 9-0. Who would have thought we'd get to see a 9-0 decision in an abortion case? Says no standing. And you've got the main opinion by Justice Kavanaugh, and Justice Thomas adds an exclamation point to the standing theme. He not only buys that there's no standing here, he has a question about whether this association standing should ever be accepted. All right, so how did the Supreme Court, even the people in the Dobbs majority, come to the conclusion that the plaintiffs here had no right to challenge this expansion in the use of a pill that is causing hundreds of thousands of abortions every year, and that the states are apparently powerless to prevent? So the Solicitor General at oral argument makes a concession, and he says, yes, the Church Amendment means that doctors cannot be forced to perform abortions if they have a religious or conscience-based objection. That's true even in a healthcare desert. So if you are out in, I don't know, Dumas, which might be a healthcare desert, or I don't know, Ozona, or some rural part of Texas, and you're an emergency room physician and there really is nobody else, and someone comes in and it's an emergency and they really need an abortion, but you believe that that is against the will of God or against your conscience, you do not have to perform one, and you can't be punished for that. All right, so once the Solicitor General says that, the case, at least according to some, starts to look a little different, because this argument starts to disappear. This argument starts to disappear. All right, what else does the Supreme Court say when it says that there's no standing here? It says, look, plaintiffs, show me how you've been punished. Show me how anyone's threatening to punish you. No one's threatening to punish you. And you've got this diversion theory, right, about how you're going to have to spend more money educating people because the government has enacted a regulation you don't like. And they say, well, maybe, but that's a really broad theory. That every time supposing the EPA were to roll back emission standards for power plants, and now you have to spend more time treating asthma patients, does that mean that suddenly doctors have standing to sue about the EPA's emission standards? Or supposing that a local government relaxes its building codes in a way that could cause there to be more fires, can firefighters now sue because they're having to spend more time? And so the court is unwilling to buy this diversion theory. As far as if you're looking for news in this case, this I think is a piece of news, that this idea of organizational diversion is not going to work. And because no individual has standing, the associations don't have standing. On the organization front, the court basically says, look, essentially you've dressed up ideological injury, Sierra Club versus Morton kind of ideological injury, and tried to restate it as, well, we have to spend money opposing what you're doing. But the court says that's just going too far. That would let anyone have standing. The plaintiffs did have a case called Havens Realty versus Coleman, which was quite helpful to them in that they were pushing really hard. And the Supreme Court, I think, basically distinguishes Havens into oblivion. And so technically they don't overrule it, but I think you're going to have a very hard time citing Havens if you're representing an organization and seeking standing. The court basically says, look, if we accepted this interpretation of Havens, That would mean that all the organizations in America would have standing to challenge almost every single federal policy they dislike, provided they spend a single dollar opposing those policies. All right. And what about the argument? Well, what the FDA did here was clearly lawless. It didn't follow administrative law. It was a bad idea. And if you don't let these anti-abortion doctors sue, well, nobody's going to be able to sue. And that means the government can do lawless things. And the Supreme Court repeats what it has said several times, which is, well, that's just too bad. Even if, that is, they cite Clapper, they cite Valley Forge, the assumption that if these plaintiffs lack standing to sue, no one would have standing is not a reason to find standing. Some issues are just not justiciable. They go to the legislature, they go to the executive, and they also throw in maybe somebody does have standing. I've sort of been trying to think about who that might be, and I haven't really gotten a good answer yet. So maybe someone in the audience will have a good theory about who does have standing to challenge the FDA's loosening of these regulations. All right, you've got Justice Thomas with one of his famous lone concurrences, in which he basically says, you know, associational standing is a really bad idea. Really, it's sort of a class action in disguise, and we have class actions, and there's also a problem of asymmetric preclusion, which is what happens when the association loses. Apparently, that doesn't preclude other members from suing, and so doesn't think you should have associational standing. He might be right, but at the moment, he has only one vote. The other justices didn't want to deal with that. All right, so what's the summary? You got to take standing seriously. The very clever theories of the plaintiffs about how they were injured did not work. And what about mifepristone? Well, that's going to rest with Congress, which of course could regulate it in different ways. That's going to depend on the executive branch. Who controls the executive branch, which might treat distribution of mifepristone as the distribution of an abortifacient and make it unlawful and start to criminally prosecute under the Comstock Act. That might depend again on the executive branch, because after all, why couldn't they just go back to the original approval or the 2016 approval? That now doesn't get evaluated under Chevron. It gets evaluated under Loper-Bright. It depends on the states, because after all, states could try to regulate ingestion of the pills. Texas has laws which are not particularly effective, which attempt to restrict receipt of it. And it also might depend on medical research, which might develop additional methods of achieving an abortion. All right, that takes me to Moyle, and hopefully we can get through this. So this is about EMTALA. And again, I do think a little history here is useful. We have to go back to 1986, and some hospital emergency rooms had the practice of performing a financial biopsy before they would treat you. They'd see if you had any money, and while they were investigating, of course, you could die. And if you didn't have money, they would say, sorry, we're not treating you. So EMTALA, the federal Congress doesn't think this is good, and they enact as part of a big tax bill, a bill that restricts the ability of hospitals participating in Medicare to engage in dumping. In other words, they say, look, if you want to participate in Medicare, you've got to agree to these provisions about what happens in your emergency room. And what the rule is that if you come to a hospital that has an emergency room, which explains why some don't, the hospital has to first determine, do you have an emergency medical condition? And if you do, then they've either got to stabilize you or do the right thing to transfer you to another hospital. They can't just dump you out onto the street or tell you we're not doing it. So we have a setup for a possible conflict between EMTALA. Oh, and by the way, just add here, there are penalties for violating EMTALA. It's not just like you get a slap on the wrist. Well, what do you mean by an emergency medical condition under EMTALA? And it does not mean you're about to die. I suspect that many of you have been to emergency rooms for things that are unpleasant, but not fatal. And they still treat you, and they're still obligated to treat you. So what does it mean? It means a medical condition manifesting itself by acute symptoms of sufficient severity, such as the absence of immediate medical attention, could reasonably be expected to place the health of the individual, or with respect to a pregnant woman, the health of the woman or her unborn child, and that creates all sorts of complications. So place your health in serious jeopardy, serious impairment to bodily functions, or serious dysfunction of any bodily organ or part. So that's when a hospital must treat you, or an ER physician must treat you, or they can get in big trouble under EMTALA. But there's another provision of EMTALA, which the people like Idaho like to cite, which is to say that EMTALA is not a license to regulate the practice of medicine. Nothing in the subchapter shall be construed to authorize any employee to exercise any supervision or control over the practice of medicine. And so they say, look, the circumstances under which abortion are performed is the practice of medicine, and therefore the federal government should keep its paws off, and it shouldn't use this EMTALA provision, which was designed to prevent patient dumping, as an excuse to start to overturn Dobbs. Okay, that's so where do various people draw the line on where EMTALA requires a hospital to perform an abortion? And I think we have three lines that have been drawn. One, I'll start with the strictest, which is the Idaho line. The Idaho line is you've got to show that the woman is about to die. Okay. And if that's the case, yes, we'll let you perform an abortion in Idaho. Otherwise, no. That's what their statute appears to say. Texas, under its trigger law, basically creates an exception for when there's a life-threatening emergency, although it then, which you might think sounds just like Idaho, but then it talks about how it could lead to a threat to a bodily organ or function. So Texas law is a little bit murky on how bad it has to be. That gets cleaned up a little bit in the Zlorowski decision of the Texas Supreme Court. And then we have the Biden EMTALA guidance, which takes this position. An emergency medical condition may include a condition that is likely or certain to become emergent without stabilizing treatment. So it's sort of a condition that could be an emergency, and it doesn't even have to be life-threatening. So you can see sort of a gap between when the Biden administration thinks that EMTALA requires hospitals to perform an abortion, and when Idaho and Texas say, but you can't perform an abortion. And lest there be any ambiguity, the Biden administration says, when a state law prohibits abortion and does not include an exception for the life of the pregnant person, or draws the exception more narrowly than EMTALA's emergency medical condition definition, that state law is preempted. So, this invites the lawsuit. You've got basically a conflict between Idaho and Texas and probably some other states and EMTALA. So I've told you what the Idaho Law Defense of Life Act does. It's one of these statutes that was passed in the hopes that Roe and Casey would be overturned, and which turned out to be the case. And it says that the physician has to make a good faith medical judgment that the abortion was needed to prevent the death of the pregnant woman. The fact that the woman's health might be jeopardized by continuing the pregnancy, that doesn't count. The circumstances under which the woman was impregnated doesn't count, nor does the fact that the fetus is having problems. They might not die. They've got serious problems. That doesn't count either. All right. And we've got the Texas law, which I think I mentioned. It shares some of the no rape or incest exception, no fetal abnormality exception, but it does have this passage, a life-threatening physical condition caused by the pregnancy that places the female at risk of death or poses a serious risk of substantial impairment of a major bodily function. All right. So this law in Texas, which I do want to focus on, has a major effect. Okay. The number of reported abortions in Texas in 2021 before Dobbs is 50,000. Dobbs basically cuts it down to 86. Yes, there were 17,000 before Dobbs was decided, but after Dobbs is decided, we go down to 86. In 2023, there were 62 reported abortions in Texas, of which only 14 were surgical, which leads me at least to believe that 48 of them were not in really emergency circumstances. And in 2024, as of last report, there were 10 abortions in Texas, of which 2 were surgical. So huge decline in the number of abortions as a result of both SB 8, the civil penalty law, and the Texas trigger law revitalizing a criminal prohibition. All right, so we've got two lawsuits about EMTALA preemption. One is the Idaho case, that's Moyle, and one is the Texas versus Becerra case. And I have color-coded the results. Red means that it's kind of a conservative anti-abortion result. Blue means that it's sort of a liberal pro-choice result. And you can see that we get different outcomes from the two different courts. The Ninth Circuit was all about to decide the case, and then the Supreme Court grabbed it. And the Fifth Circuit basically buys the argument that EMTALA does not regulate the practice of medicine. Yes, EMTALA requires you to do things in an emergency, but not things that are illegal under state law. You should know, and this may be the most important thing, there is a petition for cert that was filed in the Texas versus Becerra case. It was filed in April, and as of yesterday, they hadn't done anything. So that's sitting up there. It might come back. All right. So both sides really want to win the case here. And so Idaho says, well, our law isn't as strict as you might think. And the US thinks, well, EMTALA isn't as tough as you might think. Idaho says it doesn't require objective certainty or a particular level of immediacy before an abortion can be necessary. The Idaho legislature clarifies that removal of an ectopic pregnancy or a molar pregnancy is not an abortion, which I think clearly is not an abortion. And it changes whether the life of the mother thing is an affirmative defense, which would require it to be proven, or an exception, which shifts the burden of proof. The US, for its part, says, we never required abortion. If it's just for mental health issues, EMTALA doesn't require that. And it reemphasizes that if the physician has a conscience objection, they don't have to perform an abortion. And Texas, in the meantime, is also clarifying its law in a case called State versus Zorowski, not as much as many people wanted it to clarify it, but it did say that life-threatening physical condition is not necessarily one actively injuring the patient. It is a condition that has the potential to kill the patient. It doesn't require the life-threatening physical condition to have already caused damage before a physician can act to preserve the mother's life. And we get a concurrence from two of the justices, Justices Busby and Lehrman, saying, hey, Texas Medical Board, could you please issue regulations that would prevent physicians from being terrified that they're going to go to prison for performing an abortion because a jury disagrees with them about whether an emergency really existed. The short version is the Texas Medical Board has thus far declined the invitation of some scholars, including me, and the Justices Busby and Lehrman. All right. And so as Justice Kagan recognizes in her concurrence in the Idaho case, and as Justice Jackson recognizes in her mostly dissent in the Idaho case, there is clearly a gap between what Idaho prohibits and what EMTALA demands. And this is putting ER doctors and other OBs in a very difficult position. And for those of you who have seen the billboards I've seen them on 59 saying, wouldn't you like to go practice in New Mexico? It's because, I think in part, of this situation. All right. So actually, we did talk about that. I told you that at the beginning, the punchline is the Supreme Court says, hey, we shouldn't have taken this case. We should have waited till we had more information. We have four justices who think, no, we should have taken this case. We have Justice Jackson who thinks we should have taken this case because the Idaho statute clearly is preempted. And we have Justices Alito, Thomas, and Gorsuch who think we should have taken the case because the Idaho statute isn't preempted. And they sort of all agree, hey, nothing's really changed. Yes, the lawyers said some things in court, but you can't really rely on that. And so the reasons that we took this case in the first place still exist, but they lost. And so they had, you got a sort of a strange alliance of Justices Roberts, Kavanaugh, Barrett, Kagan, and Sotomayor, all of whom say that we shouldn't have taken the case right now. Barrett, Roberts, and Kavanaugh at least sort of attempt to explain it. And they talk about these concessions and how with the concessions, the situation for Idaho really isn't as problematic as we thought it originally was. There's supposedly an inside story from Joan Biskupic, which you can find on CNN, about what really happened here. Is that true? I have no idea. All right, so the big issue is actually just still with us. It's lurking, and if the Supreme Court takes cert in the Texas case, maybe we'll reach the merits. And we've got sort of two issues. The issue is, first of all, we have this argument that spending clause statutes such as EMTALA shouldn't have the same preemptive effect on state laws as your sort of general federal statute. And it's kind of true that that is a novel issue, that this case isn't exactly the same as Dole or NFIB, where there are 10th Amendment concerns, and at least 3 justices thought this was an interesting issue. I think some of the other justices thought, what difference does it make? The preemption clause is the preemption clause, but that could come before the court, and that could be a big deal if they issue a ruling saying that the scope of preemption is narrower, where Congress enacts the statute pursuant to the spending clause rather than one of the other provisions in the Constitution. And then you've got the basic issue of, okay, how do we reconcile a federal law that appears to require treatment of an emergency, but A, the statement in the statute that it's not supposed to regulate the practice of medicine, and B, you do have this thing in EMTALA saying that you also have to consider the life of the unborn child, at least in some circumstances. So maybe next year I'll be before you explaining how the Supreme Court decided that, but there's always politics, and the Supreme Court could say, let's wait for an actual prosecution under one of these statutes where preemption is raised defensively. We'll have a concrete record. Of course, in the meantime, we're going to have doctors who have any idea what the law is when a patient comes before them seeking an abortion, and therefore may refuse to do it or send them out of state. Second, if President Trump is elected, then his people might well say, yeah, we agree. States are free to regulate abortion, and EMTALA was never intended to do this, so we're not going to pursue EMTALA violations. And in the fantasy world where one party gets control of Congress, Congress could write a statute that left it free from judicial interpretation. They could just decide whether there was preemption or not. And that, I think, is all that I have to say. And so I will let others go forward.
Thank you, Professor Chandler, for a very important conversation about these really great issues. Thank you for your participation. I'd like now to introduce our next panelist, which is Professor Emily Berman, who will discuss ballot eligibility, presidential immunity, and the January 6th prosecution decisions. Professor Berman is the William B. Bates Distinguished Chair in Law, Professor of Law, and Assistant Dean of Faculty Development. She's a constitutional law scholar with expertise in executive power and national security law. Her scholarship identifies the areas of law where executive power is subject to inadequate restraints and proposes novel mechanisms for imposing checks and balances and democratic accountability on the executive branch. Professor Berman teaches national security law and constitutional law. She graduated with her JD, magna cum laude, from NYU Law School, where she was also editor-in-chief of the NYU Law Review. She also received her LLM in international law from NYU. After graduating from law school, she clerked for the Honorable John M. Walker, Jr. of the Second Circuit Court of Appeals. And before joining University of Houston Law Center faculty in the fall of 2014, she taught for 2 years and was a visiting assistant professor at Brooklyn Law. And she previously served as a Furman Fellow of the Brennan Center at the NYU Law School and held various other positions. She's been published in top journals such as Minnesota Law Review, Iowa Law Review, Boston University Law Review, Fordham Law Review, and NYU Law Review. Let's welcome Assistant Dean and Professor of Law, Emily Berman.
Thanks very much, Dean Baines. I think I'm not actually officially Assistant Dean until September 1st, but we could let that slide a little bit.
Close enough.
So thanks so much to everyone who has stuck around for the last speaker. I am going to share my screen with some PowerPoints. And so as the dean said, I'm talking about 3 cases today. And this is the order in which I'm going to discuss them. Fisher versus the United States, Trump versus Anderson, and then Trump versus the United States. In some way, my job is simplified in that all of these cases arise out of the same nucleus of facts. These are all cases relating to consequences of post-election efforts by President Trump to alter the outcome of the election and the events of January 6th. So to start, Fisher is sort of most specifically about January 6th. Joseph Fisher himself was a former police officer from Pennsylvania, and he was at the Capitol on January 6th and then, in fact, entered the Capitol. And one of the statutes that many of the January 6th defendants have been prosecuted under is an obstruction statute. And the question in this case, and in many others like it, are whether what he actually did constituted obstruction within the meaning of this statute. So again, it's a statutory interpretation case. It's a 6-3 split with Justice Roberts writing the majority, but it's not the 6-3 split we are becoming used to seeing. Here, Justice Barrett joined Justice Kagan and Justice Sotomayor in dissent. She actually wrote the dissent, and Justice Jackson joined the majority. So it really comes down to an intra-court dispute about how to interpret the statutory text. So what is the statutory text? So USC 1512C 1 and 2, this is a statute that was enacted after the Enron scandal that basically says, hey, when there are ongoing proceedings, you can't shred documents because that might impede efforts to seek justice. And so it's written very much in the terms of what went on in that case, talking about altering, destroying, mutilating, or concealing records or documents. But then it's got this sort of catch-all provision that comes afterwards that says, or otherwise obstructs an official proceeding. And what Joseph Fisher argued is that provision 1512C2 has to be interpreted in light of C1 and is limited by it. And therefore, it applies only to acts that actually affect the integrity or the availability of evidence. So it doesn't mean otherwise in any other way. It means some other way of impairing the ability of the proceeding to use evidence. The government, on the other hand, said, no, otherwise means any other kind of obstruction, including physical obstruction of the proceeding. And the majority came down on Fisher's side and basically said, we're going to rely on traditional canons of statutory interpretation, one of which says that a collective or general term at the end of a list is typically controlled and defined by reference to the specific classes that include, that precede it. And so here, the idea is just that a general phrase like otherwise can be given a more focused meaning by reference to the terms that it's linked to. And in some ways that the majority points out, this ensures that regardless of how complicated a sentence might appear, each part is going to have effect. None of them is going to be redundant because you've added a clause literally broad enough to include everything that came before. And he uses an analogy from football to make his point. And he says, imagine that there's a rule that players cannot grab, twist, or pull a face mask or helmet or other equipment with the intent to injure a player or otherwise attack, assault, or harm any player. And he said, if that's the rule, then it shouldn't be interpreted as being directed at hurting someone's feelings, because all of the listed prohibitions concern dangerous physical contact, and trash talk is just not of the same ilk. Plus, he said, if Section C2, the otherwise, covers all forms of obstruction beyond the ones focused on in C1, then there would be no reason to have Section C1 at all. So in searching for a limiting principle, the court was concerned about excessive punishment. The statute does carry a prison term of up to 20 years. And also the fact that it could be interpreted to apply to things like protesters or activists or lobbyists. And for example, Justice Alito at oral argument asked whether if someone's standing up in the Supreme Court during oral argument and shouting something out or waving a sign in a way that interrupted the proceedings, would that constitute obstruction of an official proceeding under this statute? And could that person be imprisoned for 20 years? And so in interpreting the statute, the majority says, we are going to interpret C2 in light of C1, and it's a crime to impair the availability or the integrity of records or documents or objects used in an official proceeding, even if you do so in a way that is different from the types of impairment discussed in Section 1. And so, for example, it's possible to violate 1512C2 by creating false evidence rather than altering or destroying incriminating evidence. So that's the sixth justice majority. The dissent, as I said, written by Barrett, says, look, under the rules of statutory interpretation, we stick to the text. And this text might be very broad in the scope of criminality that it applies to, but that's up to Congress to decide. And who gets prosecuted for it is up to the president to decide. There's just no role for the court to play in deciding how this law should operate. Congress already decided it, and the executive brought the prosecution. And she simply relies on the definition of the word otherwise to mean that, to say that the text is clear, otherwise means otherwise. And she accuses the majority of doing textual backflips to find some way to narrow the reach of Section C2. And she says, okay, Justice Roberts, I see your football analogy, and I raise you a football analogy, and said, his analogy doesn't actually mirror the statute at issue here, because that was all about intent to injure a player, and it was otherwise attempting to injure a player. Whereas Section C2 is about impeding an official proceeding, doesn't have anything to do with the evidence. She says it has a separate object, which is the proceeding rather than the evidence. And so she says a more parallel construction would be, you can't punch, choke, kick an opposing player with the intent to remove him from the game, or otherwise hinders or interferes with the game, which could include, tackling the referee or what have you. So that is her response. Justice Jackson writes a concurrence. She joined the majority, but she writes a concurrence to clarify that in her view, the January 6th meeting of Congress qualifies as an official proceeding under the statute, which was one of the questions that had been on the table in lower courts that hadn't made it up to the Supreme Court. And she says it might well be that Fisher's conduct, as alleged here, does in fact violate Section C1. If he did something to impair the availability or integrity of things used at the January 6th proceeding. And so the lower court should go back and look at whether his actions can fit within the scope of C1. So one of the reasons people had their eye on this case is that Fisher is not the only January 6th defendant who has been charged with this crime. And in fact, there were 355 out of the 1,427 defendants who've been charged in connection with January 6th that were charged with this statute. So that's the sort of universe of people who might be impacted by this decision is that 355. But no defendant was charged solely with that offense, and most of the violent actors were charged with multiple felonies in addition to this one. More than 100 of those have already been resolved through plea deals or acquittals, so this is irrelevant. And so the 52 cases that are most likely to be impacted by this ruling are those where the felony of obstruction was the only felony that was charged. They may have been convicted or charged with other misdemeanors, but this was only the only felony. 25 of those 52 have already served their sentence. So there are 27 individuals who still owe time on their prison terms, and many of those will probably have their prison terms shortened. And in fact, after this case was decided, the district judge ordered all of those prisoners released because many of them probably will be subject to sentences shorter than the time that they have already served. And then, of course, the one January 6th defendant charged with this crime that might be top of mind for lots of people is Donald Trump. And his involvement, this is one of the points that Justice Jackson was making, his involvement with the electoral certifications presents facts that are very different from those like Fisher, who were in the invasion of the Capitol. And so now that this case is back in the district court, the district judge in DC is going to have to decide whether the machinations surrounding the alternate electors constitutes impairing the evidence for an official proceeding. And as I'll get to in a minute, if those acts are nonetheless immune. So Judge Chutkan has her work set out for her by this term of the Supreme Court. But the upshot is that it ends up having very little practical effect, though going forward, that statute is going to be interpreted more narrowly than the government had been using it to date. Okay, so the next case is Trump versus Anderson. And this is a case that voters in Colorado brought to challenge President Trump's access to the Republican primary ballot in Colorado on the argument that he is ineligible to be president because of Section 3 of the 14th Amendment. And the question here is, can Colorado decide that a candidate is ineligible to be president based on Section 3 and exclude him from the ballot on those grounds. And the courts, in a nominally unanimous but kind of not unanimous per curiam decision, says no, Colorado can't do this. So first, what exactly does Section 3 of the 14th Amendment say that may may or may not apply to former President Trump? So this is a post-Civil War measure, of course, the 14th Amendment was. And this section of the 14th Amendment was essentially a means of preventing people who had been officers of the United States and had then joined the Confederacy, to prevent them from then coming back and taking over the US government again. And so it says that no person shall hold any office under the United States who has previously taken an oath as an officer of the United States to support the Constitution and then engaged in insurrection. But the provision goes on to say if Congress votes by a 2/3 majority, then they can remove that ineligibility from that particular individual. And so the Colorado Supreme Court in this case actually agreed with the plaintiffs that President Trump had been an officer under, had held an office under the United States and taken an oath to support the Constitution, that he had engaged in insurrection and was therefore ineligible to run for president. And the Supreme Court reversed. And there were lots of ways that the court could have disposed of this case. There were innumerable arguments out there, from the wildly implausible to the potentially plausible, things like the president is not an officer of the United States, and the presidency is not an office under the United States. Whether Trump actually engaged in insurrection. They could say what Trump did doesn't qualify as engaging in insurrection. They could have said the process through which the Colorado District Court determined that President Trump had engaged in insurrection was insufficient process, violated his due process rights. They could have said that the President Trump's actions were protected by the First Amendment, in particular his speech at the Ellipse on that day. But they didn't go any of those routes. Instead, they adopted an argument that nobody had made in any of the lower court proceedings, or in any of the amicus briefs, or in any of the many articles and blog posts written by law professors in the weeks and months leading up to the case, and instead relied on the fact that the Constitution gives Congress the power to enforce the 14th Amendment. Section 5 of the 14th Amendment says that the provisions of this amendment will be enforced through Congress. And what the court, with the majorities, so this is one of the points on which the concurrence and the per curiam differ, where essentially the opinion says that therefore it is up to Congress, and it leaves unclear whether it's can only be up to Congress, which is how the concurrence reads it. So to decide how determinations regarding an individual's eligibility under the 14th Amendment are going to be determined. So they say states can disqualify people holding or attempting to hold state office, but states don't have any power under the Constitution to enforce this provision with respect to federal offices, especially the presidency. As I said, none of this idea had not come up. But it did allow the court to sidestep a lot of the sort of implausible arguments of, is the president an officer of the United States, and also not have to explicitly answer the question whether Donald Trump engaged in insurrection. And it's basically a sort of pragmatic decision where they say, look, state by state resolution of this question would result in a patchwork where some candidates were declared ineligible in some states, but not in others. And this different ballots in every state could generate chaos either before or even after the election. They also point out that, Congress has the ability to render someone eligible again by a 2/3 vote. And they say if states could declare them ineligible, then that would allow states to put the burden on Congress to rebut their determination, and states shouldn't be able to put Congress in that position. There's no history, they say, of states enforcing this provision, but lots of instances when Congress did so. And so, like any other provision of the 14th Amendment, this is something that's meant to be enforced by Congress. So at the end of the per curiam, the opinion tries to sort of reconcile itself with the concurrence, and says, look, the only thing that the concurrence doesn't like about this opinion is that Section 5 of the 14th Amendment vests enforcement of Section 3 in Congress. And the opinion says, look, there are lots of reasons for our opinion. Each of them is necessary to the resolution of this case. And the concurrence agrees with most of them. There's just that one that they don't agree with, but there's all these other ones, and the case needed all of them to come out this way. And so really we're all in agreement. Now, the concurrence was a joint concurrence by Sotomayor, Kagan, and Jackson. And a little bit of internet sleuthing by a reporter discovered that the metadata for the document, the file that was posted, indicated that it had originally been an opinion by Justice Sotomayor concurring in part and dissenting in part. But it ended up being a joint concurrence. And I'll mention one theory as to why that is in a minute. But they start out by quoting Justice Roberts in his Dobbs concurrence back at him and say, if it is not necessary to decide more to dispose of a case, then it is necessary not to decide more. And they say, look, the patchwork argument, the fact that we could have all these different presidential ballots in different states, that is sufficient to resolve the case, and we should have stopped there. That's all we need to decide. We don't need to decide anything else about how Section 3 of the 14th Amendment is enforced or who gets to do the enforcing. We just know that states aren't the appropriate entity. And by going further, the concurrence argues the opinion of the court decides novel questions to insulate this court and petitioner from future controversy. So they go through some ways in which they think that sort of the text of the provision rejects the idea that Congress has to enact legislation to establish procedures to determine who is qualified under Section 3, because they say, look, if Congress can decide by a 2/3 vote that someone is eligible, then why would the Constitution require, why would they require that supermajority if a simple majority of Congress could enact implementing legislation setting out the standards? And they argue all the other provisions, the substantive provisions of the 14th Amendment, like the Equal Protection Clause and the Due Process Clause, those are all self-executing. Those don't need Congress to implement them. And the same is true for other limits on eligibility for the presidency, like the 2-term limit and the age requirement as well. So they say, does that mean that a state can't prevent someone from being on the ballot if they're for the presidency if they're 25 years old? Does Congress have to enact provisions for determining that as well? And all of this, it seems, is driven by a concern that the opinion of the court forecloses other means of enforcing this requirement that don't rely upon Congress and may, in fact, rely upon judges. So, for example, if someone is prosecuted by an attorney general who has been appointed by a president who is arguably ineligible to hold the office, they could raise that as a defense, and the question would then be before the court: is this person actually ineligible? Or if someone is denied Social Security benefits and says that the executive is barred from office, and so all of the administrative decisions that took place under his administration are invalid. So they want to preserve the ability of this provision to be enforced through multiple different mechanisms, and they argue that the way that the opinion is written, it has limited that enforcement to Congress. Whether it does or not is a separate question, but that seems to be their view. Justice Barrett also wrote a concurrence. She says she too would have decided nothing more than the fact that the states can't enforce Section 3 against presidential candidates. Doesn't require us to address the complicated question of what is required to enforce it. But then she goes on to chastise Kagan, Sotomayor, and Jackson for being too strident. She says, in my judgment, this is not the time to amplify disagreement with stridency. The court has settled a politically charged issue in the volatile season of a presidential election. Particularly in these circumstances, writings on the court should turn the national temperature down, not up. For present purposes, our differences are far less important than our unanimity. All 9 justices agree on the outcome of this case. That is the message Americans should take home. Maybe that is the message Americans should take home. I don't think it's the message that the opinion actually sends. It's clear that the court tried to achieve unanimity, and Justice Barrett wants us to believe that it did. But this opinion does not come across like other opinions that have been viewed as sort of particularly authoritative because of their unanimity. Some things like Brown versus Board of Education, or the Nixon case that required the president to turn over his Oval Office tapes. So that's one takeaway, is we're not sure. They could have issued a narrow, truly unanimous opinion. They didn't. We don't know why. Second, it's not clear what the stuff that they did say beyond just what the concurrence would have held. We know that states can't enforce provisions against federal officials. We know Congress can pass implementing legislation, but we don't know much more than that. So can Congress refuse to accept electoral votes for Trump because they determine that he is invalid for the presidency when it comes time to count the votes, for example? The concurrence seems to say that that congressional legislation is the only means the majority has left. But the majority never actually says that. And so one of the theories is that the concurrence was written as a partial dissent in response to an earlier version of the majority of the court's opinion, and that the draft of the court then sort of pared back some of the language that the dissent had objected to. Okay, so of course we're running behind, and so the biggest case is, I have 3 minutes to talk about, but I'll take a few more minutes than that. So Trump versus the United States was the question whether, and if so, how is the former president immune from prosecution for official acts that they took while in office? And in the lead up to the case, the broad consensus was there's no such thing as immunity, Trump loses. That's what the district court said. The DC Circuit affirmed that on a panel that included a Trump appointee. After oral argument, it became clear that maybe there would be sort of a narrow immunity for core presidential powers, whatever that was. But when the opinion came down, I think it's fair to say that it was shockingly broad immunity that the court extends to former presidents. And they do it through establishing these 3 categories. So one is core presidential powers, things that are conclusive and preclusive executive powers. So presumably that's things like the pardon power, something that is assigned directly to the president. Absolute immunity, no liability ever for those acts. All other official acts are also subject to immunity unless the prosecution can show that it would pose no dangers of intrusion on the authority and functions of the executive branch. So it's a presumptive immunity, but it sets an incredibly high bar for the prosecution to meet. And in the opinion itself, the court says, we think this is presumptive. It may end up that we decided it should be absolute, but for now, assume it's presumptive. And then for private acts, there is no immunity, which is not remarkable because even Trump had not asked for that. But then they go even a step further and say not only is the president immune from prosecution for any official acts, but the prosecution is also barred from using evidence of official acts to prove charges that are based on unofficial acts. Justice Barrett dissents from the majority on this point. So this is a 5-4 portion of the opinion. And she gives an example. She says, look, if the president's charged with bribery for selling a pardon, the government needs to introduce not only that he took the money, but also that he issued the pardon. And that is a core executive power. So how are you supposed to prove bribery if you can't introduce evidence that the president issued a pardon? And the majority drops this sort of cryptic footnote in response to this hypothetical, saying, well, public records could be used as evidence. So the fact of a pardon could be shown using public records. You just can't get the evidence actually from the president. So they say the prosecutor can admit evidence of what the president allegedly demanded, received, accepted, or agreed to, but he can't admit testimony or private records of the president or his advisors probing the official act itself. Nobody knows what that footnote means. It's not clear what constitutes a public record, first of all. But in addition to saying public records are fair game, it seems to also suggest that maybe other kinds of evidence are also okay as long as it's not, private records of the president or his advisors. But what this means is that Judge Chutkan in the DC District Court has her work cut out for her, because now she has to go through the entire indictment against President Trump and pick out what's an absolutely immune official act, what are other official acts, and can the prosecution overcome a presumption, what can be used as evidence and what is off the table for evidence. The court did go through some of the evidence against Trump and opine on whether it was absolutely immune or an official act or a private act. And I can talk about that in the Q&A. I think the most striking conclusion is that they said that the pressure on the Justice Department to initiate an investigation or to announce an investigation into election fraud, and when the president threatened to remove the acting attorney general if he didn't launch such an investigation, well, that is the part of the president's removal powers, which is a core executive power, and it's part of the exclusively executive authority to investigate and prosecute crimes. And therefore, that is absolutely immune from prosecution. And so there are ways to read the opinion as providing incredibly broad absolute immunity, but even if that is a more narrow set of acts, the fact that it applies to all official acts and the bar to overcoming the presumptive immunity is so high, really gives the president a lot of leeway. So this remanded to the district court to assess what qualifies as official, but it provides very little guidance. Just quickly, there were two very strong dissents, Justice Sotomayor and Justice Jackson. Justice Sotomayor's point was to say that under the majority's rule, a president's use of any official power for any purpose, even the most corrupt, is immune from prosecution. And she goes back to some of the examples that had come up in oral argument. Can the president order SEAL Team 6 to assassinate his political rival? And she goes on with there are several others that she and others have raised. And the majority calls the dissent alarmist, but it never explicitly rebuts any of the examples that she provides. So it's not like the majority said, oh, no, of course he couldn't order SEAL Team 6 to assassinate a political rival. They're just silent on that issue. Jackson also dissents, but she wanted to point out that by making this about whether an act is official or unofficial and making that boundary fuzzy, whether the prosecution can overcome a presumption, that means that it's taking more power to the courts. And that all of these decisions are now going to run through the courts, who get to decide what is it that the president's going to be able to be held liable for and what isn't, by determining what is an official act and what is an unofficial act. So obviously there's lots more to say about that, but I will hopefully work some of it into Q&A, and I want to be sure to leave time for that. So I will wrap up there.
Great. Thank you, Professor Berman. Can Professor Salib and Professor Chandler come back? And can you move your PowerPoint, remove your PowerPoint, Professor Berman? Great. Thank you. So that was great. That was excellent. And so I encourage everyone in the audience to give us some questions. I'll lead off with some observations and then a question. Basically, in terms of, I want the panelists to think about trends, and I'll identify two trends I've seen. One seems to be Amy Coney Barrett is taking sort of a separate, different kind of position than some of the people who thought she might ally herself with the 6-person majority all the time. It seems like she has carving out a separate role, and she may evolve even further over time. So I'm curious what you think about that. And the second thing, I guess, what I would see, it's the Professor Berman's point about the Trump cases, I guess I would loosely call them. It seems as though a lot of that revolves around what you perceive to be the role of the president, and whether the president is, was it the unitary executive function of the president, and whether the president has all this power. There's a Kavanaugh Law Review article that he had written, I think, in the 90s or so about that particular issue. And, in making the strongest argument for their case, there certainly has been a lot of investigations of presidents, as long as I can remember, whether it's by Congress or by special prosecutors. And now we've gone to this cross this precipice where now there's actually been an indictment of a president. And so, one is like, well, maybe the justices have a thing, or maybe this whole thing of like removing this from this, the fear that this will go further and further. Maybe that's just a legitimate concern. So those are 2 points. One is, have you seen any evidence of Amy Coney Barrett sort of moving in a different direction? And also the thing about the presidential immunity cases. Any thoughts?
Well, I can just continue quickly with a couple of thoughts on the immunity decision. I think one of the striking things about the decision is that it was almost entirely consequentialist, right? We weren't relying on history, we weren't relying on text. To the extent that any of those things exist, they push in the opposite direction. Everyone assumed Richard Nixon could be prosecuted, or he would not have accepted a pardon. But the majority is really worried that if there's criminal liability, presidents are going to be hesitant and fearful, and they're not going to be able to act boldly and decisively. They'll always be looking over their shoulder. And that's what they're most concerned about. Whereas the dissenters say, okay, maybe, but what's worse? A president who thinks twice before making a decision, or a president who's completely above the law and knows that he's above the law. And so in some ways, it's sort of like, I feel like the majority's decision makes perfect sense if you believe that we're always going to elect presidents who stay within the confines of what we would think of as appropriate exercises of their power. But the fact that we've already had a president who tried to stay in power beyond what he was entitled to seems to indicate that the concerns that the dissenters have, like, we're already facing that versus your speculative concern about what might happen in the future. So I find that hard to understand. But I do think, Dean Baines, it goes back to this idea of a very robust executive. That's part of their judicial philosophy. A lot of them worked in the executive branch, and I think that's coming through here.
Thank you. Any other thoughts? Anything about Justice Barrett? Amy Coney Barrett? Have you seen some? Do you see any difference that you thought that you might have anticipated?
Yeah, I don't think I'm not sure I know her record well enough to say whether this is a departure or not, but what I see from this term is a battle between wanting to punt, basically, and not, taking abortion cases and then deciding on dubious reasons that things have changed, they don't want to deal with it, and some of the other examples, and then some very inflammatory, aggressive actions. And so, for example, in the Trump case that Professor Berman referenced, deciding the evidentiary issue, which was not before the court, absolutely not before the court. And if you believe in judicial minimalism, that should never have been decided by the Supreme Court. But they wanted to make their point and they went forward. And then you also see what I would regard as very high temperature dissents from Justice Sotomayor with very inflammatory language. And then you see Justice Barrett trying, at least on occasion, to say, hey, could we ratchet this down a little bit? Because I think, and this is my opinion, that people need to take seriously the consequences of inflammatory language. We live in sort of a precarious balance where we have civility, but we also have, assassination attempts, we have political violence, we have huge cleavages, and we have not really faced the costs of that spreading. But I basically agree, for what it's worth, with Justice Barrett, that some moderation in language would be a good thing for the Supreme Court on all sides.
Yeah, the only thought I had about Justice Barrett is in the net choice cases, as I mentioned in my my talk on them, she was really the justice who I think had sort of the most nuanced view of the First Amendment precedent. This idea that, well, it's really going to matter a lot exactly what kinds of decisions the social media companies are making. And even when they're implementing algorithms to help them make the decisions, or how they're using the algorithms, what they're asking the algorithms to do. And being sensitive to the fact that really can make a difference under the case law. And before she was a judge, Justice Barrett was a law professor. She wrote a fair amount about precedent and under what conditions we should follow it and what conditions we shouldn't. But I think it's interesting that in the cases where she feels that she's bound to follow precedent, she does seem to be, at least in the cases I was thinking about today, really, I think a quite strong reader of precedent.
Professor Berman, any thoughts on Amy Coney Barrett?
Yeah, I think she definitely seems to have found sort of her individual voice. She wrote separately in lots of places, and wasn't necessarily always easy to predict how she would come down. Her opinion about the evidentiary issue in the Trump immunity case, she's not always willing to get on board with some of the other, more justices that like to take, bigger steps in certain directions. But on the other hand, it's not as if she is a moderate justice. There's a whole area of law that was a glaring omission in our presentation about the decimation of the administrative state that went on this term. And she's all on board for that. She's on board for for Dobbs and that sort of thing. So she's her own person, but don't mistake that for being moderate.
Yeah. Any other trends that you all saw? What about standing? I know Professor Chandler raised that a lot. And it seems like it came up in a lot of different places. It's come up in a lot of different places in this current term. We've seen it with Professor Salib's presentation, Professor Chandler's presentation has come up in the past terms. The case dealing with the website company that didn't want to provide website services to LGBTQ couples. You've seen over in the affirmative action case where it was an association and that brought the case, but we never met any of the Asian Americans who were supposed to be part of that associate. We've seen it over and over and over, and it seems like when I was in law school, when all you were in law school, it seemed like standing was kind of clear. You sort of had or not, and then you have these cases going all the way to the Supreme Court, and then they say, oh no, we have no standing. And so, what do you think is going on here?
I thought it was interesting in not only cases I was covering, but in some of the other ones that Seth and Emily covered. The extent to which the Supreme Court seemed to sort of balk in deciding hard issues. It granted all these cases, granted cert in all these cases that in theory could have been real blockbusters. And then when the rubber met the road, and I don't know, they had to write a majority opinion, or they looking around at the world and thinking about whether they wanted to be more or less salient in the minds of ordinary Americans. They sort of in many cases sort of decided they didn't want to say very much. And one way of doing that is with standing, is by saying, look, there's a way to get rid of this case that doesn't require us to say anything about the merits, and standing is a way to do that. I didn't notice any of the standing rulings breaking a lot of new legal ground, at least in my understanding of standing, but it did seem like maybe an above average level of use of standing to get rid of cases that maybe they regretted putting on their own plates.
I think part of it too is a function of for the Fifth Circuit phenomenon, for lack of another term, that I think Bruen and Dobbs a couple terms ago sort of signaled, bring any argument you've got, because throw it at the wall and it might stick. And so a lot of these sort of way out there standing theories, people say, well, let's bring it and see what happens. And there, if you get the right judge and the right panel, they'll go along with you, and then the Supreme Court is sort of obligated to push them back down. And so I think the Supreme Court has sort of signaled open season on precedent, and people are trying to see what they can get through, and some courts are willing to go further than others. I think 11 of the court's merit cases were from the Fifth Circuit this term.
Yeah, at least 3 of the ones I covered, and maybe 4. I can't remember where Cargill came from, but yeah, 3 of mine were Fifth Circuit cases.
I just wonder what would have happened if we'd had CLEs and the internet back in the 1960s. And we heard about, people breaking precedents and expanding the law of standing beyond all recognition, and whether we'd be as critical of them then for disrespecting traditional roles. So personally, just, I think the Supreme Court's decisions on standing this term were very good decisions. I don't think that the Supreme Court should be the grand arbiter of everything that's a legal dispute, and that you ought to respect some traditional bounds. And I said for 2 years, explain to me how exactly the plaintiffs, that Alliance for Hippocratic Medicine, has been hurt. And what I think the court told us is that if it takes more than 2 sentences to explain how you're hurt, you're probably not hurt in a way that the law recognizes.
But also, I guess one of the things that it does is, like, I think as Professor Berman said, is that it allows, in many cases, there's the lower courts that are allow these cases to go forward, and the Supreme Court swats them down. And so allows, a full, robust evaluation of a lot of cases that you might not have gotten to the Supreme Court if the lower courts had found there was no standing. But it also then allows the Supreme Court to seem more judicious in its approach to the decisions. But these cases that many of you mentioned, they swatted them down, but it doesn't mean they won't rise back up, right? So in the process, are they giving the plaintiffs or future plaintiffs an opportunity to refine the kind of case that they actually bring that they might be able to decide on the merits? That's number one. And number two, do you think that the swatting down of standing, might have to do, the Supreme Court they are unelected, they serve for life, but they are, I think, Chief Justice Roberts is much more cognizant of the politics around, decision-making. You sort of saw that with the Obamacare case many years ago, where he obviously didn't want that to be an election. In my interpretation, he didn't want that to be an election year issue for the court. And so some of these issues, if they had found in a way that was positive for the plaintiffs, would have made these issues even they're salient now, but even more salient in the democratic process of electing, state Congress, senators, and the president.
Yeah, one puzzle about that for me is, like, they get to decide which cases they take, they don't have to take any of them. And yes, of course, it takes fewer votes to grant cert than to issue a judgment. And so it could be that many of these cases were 4 votes for cert and then 5 against doing anything big. And so that could explain a lot of it. But in some of them, they do look a little bit to me like the dog who caught the car, where they have these 2 really potentially big First Amendment cases that implicate the partisan balance of social media, something that's been, I think, quite obviously political since well before the court decided to grant cert. So I don't think it should have been any surprise that when it came time to decide whether, the state of Texas can forbid Facebook from taking down, what the state of Texas believes to be too many right-wing views, that would be considered controversial politically. So, it's a little bit hard to understand how they would find themselves surprised by this when it came to write the opinions.
I also read that there's been more concurring opinions than ever before by a lot of the justices, which may create some confusion with lower courts, right? So that, I don't know, is that your do you perceive that to be the case? And part of it, they said, what I've been reading is that because they've taken so few cases, they're now deciding like 60 something a year, so people are able to write more concurring opinions. And so is that your sense? What is your sense of that?
I mean, I do feel like I think there have definitely been more concurrences, and I think in some ways that's not surprising in the sense that, like, when you're changing the law, people are going to have different views on, how it's changed and how sort of a new conception should be applied in a particular place. But I also feel like, and I don't have I have no evidence of this statement, but I'm going to say it anyway. I feel like they take these huge cases, as Chris Sleeve was saying, they get to pick, and they take these blockbuster cases that sort of demand a lot of time and attention and writing. And I feel like this term, they sort of ran out of it. Like, that Trump immunity decision, a sloppy decision, in my view. It murks up the waters a way that's like just not helpful. And maybe that was sort of strategic ambiguity to maintain the votes or what have you. But it felt to me like, if you had more time to work on this, it would have been better, and you could have given more clarity on what it is you're actually trying to say.
Yeah, I think another possibility could be, the court now has a 6-vote conservative majority, and the marginal justice is more conservative than, say, Anthony Kennedy was, which means you just aren't, you have less pressure to hold the coalition together. It means you need to make fewer concessions in your majority opinion if you don't need the marginal voter, which means that you're more likely to alienate one justice and still get your majority, and then you get a concurrence out of that. So it could be a feature of the structure of the court as well.
But are they sometimes signaling in their concurring opinions what they want, what cases they want to be brought? So, for instance, in the presidential immunity case, Justice Thomas, indicated that the special prosecutor, might be unconstitutional, and then you had Judge Cannon in Florida sort of indicated, oh, this is unconstitutional. Or you had Justice Thomas, I guess, also in the Dobbs case. Well, maybe same-sex marriage is unconstitutional. Now, no cases come up for that yet, but there's been other cases where some of the judges in writing concurring opinions have signaled what they believe should come up next. Is that something unusual, have you seen, or is this because they're able to do more concurring opinions?
What I would say, Dean, is it seems to me it is mostly a Justice Thomas phenomenon. That is, I didn't count, and I thought about getting someone to go count opinions this term, in which he said, in an appropriate case, I would love to hear argument about X. And this has been going on for years, and I'm not saying there's anything wrong with that, but it's very hard for me to have two things simultaneously in my mind, which is, one, you write concurrences inviting particular legal challenges. And then second, you have Justice Roberts' notion that the court's just an umpire of, the umpire doesn't say, would you please throw a curveball outside so I can decide whether it's a strike or not? And Justice Thomas seems to be saying, yeah, I'd like to expand the strike zone to include that. So I don't know that this phenomenon goes beyond Justice Thomas, but he's certainly been quite bold in setting forth those arguments that he would particularly like to be brought before him, where I guess he feels that the law is seriously in error, and if only the court would hear it, that error could be righted.
Any other thoughts? So one thing people have talked about is the Fifth Circuit. So the Fifth Circuit seems to be becoming much more prominent and influential than it had, especially bringing these cases before it and the cases going before the Supreme Court. So is the Fifth Circuit, does it have the influence and impact in this new Supreme Court regime that maybe the DC Circuit or the Second Circuit used to have in the past? What are your thoughts?
I wonder if the Fifth Circuit's the new Ninth Circuit, actually. So, like I said, at least 3 of my cases came out of the Fifth Circuit, and in them, this Fifth Circuit got reversed, and then the case got kicked out on standing, and then got reversed. And so that's not a great record if you think of yourself as the as the court that is developing the new, more conservative jurisprudence that's then going to be the law of the land. Now, of course, there could be something more complicated going on where, like I think the Ninth Circuit used to do on some occasions, think of itself as an institution for generating theories that are to the right or to the left of the current doctrine, with the understanding that most of these are going to be rejected, but that the court needs vehicles in order to accept the ones it's going to accept. And so maybe in that sense, the Fifth Circuit isn't surprised or troubled by the amount that it's getting overturned. But to me, the analogy is really to sort of the Ninth Circuit of decades past. You're muted, Dean.
Some questions from our audience. Let's see. So there's one that's talking about, a couple actually talk about this in terms of the court losing its credibility, its rejection of precedent, among other things, a number of them that are related to that. And so what do you think is the polling seems to suggest that the court is held in lowest esteem it's been in quite some time. And President Biden has proposed, term limits and ethics reform. Do you think that the court has lost its, sort of its stature, or is losing its stature?
It's hard for me so I know that as a comparative matter, it is much less respected than it has been historically. For me, it's hard to tell whether that is specific to the court or part of a broader loss of faith in institutions and institutions of government generally. Certainly there are ways in which it hasn't done itself any favors. But I don't know that, I just don't know if it's, is it worse than Congress? is it, maybe it's just a reflection of, so all of the polarization and controversy that's out there sort of in every single walk of life that's also gone to the court.
Another possibility is that it is the court that's losing legitimacy at a faster rate, but it's not because it's acting lawlessly in a meaningful way. So like, Dean, you raised the question of precedent, and precedent is kind of famously floppy, right? There's not hard rules about when you need to follow precedent and when you need to overrule it. And so when the court does something like overrule Roe versus Wade and Casey, my intuition is probably not that, insofar as that makes people lose legitimacy and lose their sense of that the court is legitimate. It's not because they think, oh, this was a case where the court should have followed precedent. I think it's because they think, oh, I liked Roe and Casey.
Mm-hmm.
In fact, when you poll, ordinary Americans, the decision to overturn Roe and Casey was quite unpopular, and so that, I think that could explain, the court's polling, as much as these more sort of legal questions about whether it's faithfully applying its purported methodology.
Yeah,
I also think the court. Oh, sorry. Go ahead, Seth. I
was going to say, I also think social media and the way we are today, I think, is a factor. That is, again, I want to put us back in the 1960s and imagine that we had the internet. Can you imagine all the complaints about, how could you overrule Betts versus Brady? Or how could you overrule Colgrove versus Illinois? And all the cases that the Warren Court overturned. You would have memes, you would have all of the stuff. The comment section of the New York Times would be full of stuff. And so I think it's a lot easier these days for everyone to be a critic. And I'm not saying that's the whole thing. And I agree with my colleagues that the court has shot itself in the foot on several occasions. But I'm not so sure that what its efforts to change precedent and its ideological shift is any more drastic than that which occurred in the 1960s. And you saw some lack of confidence in some quarters, the impeach Earl Warren movement that existed back then. But I don't think there were the opportunities for the average person to sort of pile on the court in the way that exists today. So that's a little theory that this is partly because of social media and the ease of commentary today.
I think another factor, though, is this court, like, there is no question that this court does not think it is supposed to be answering, right? So, forget the expertise of experts. We're going to overrule Chevron. We know best what a statute says. We know when a president should be immune or not immune. So many of their decisions, we're going to decide when a state legislature has gone outside the bounds of what it's allowed to do with election law. Like, there's a whole line of cases that have taken more and more and more authority to the court. And so when, as Professor Sleeve said, they choose to inject themselves into these political disputes and make themselves the decider. And so that exposes them to the kind of reactions that people normally would have to politicians who are making decisions that they may or may not like.
And Professor Berman, if you were sitting in 1969, would you have said the same thing about the Warren Court deciding that it was better than police about when suspects should be interrogated?
Maybe.
Yeah. So,
but I would say, one of the big things that the Warren Court did was overrule Plessy. And what we saw was like armed resistance. So maybe there weren't memes, but people were, they had to call it, the president had to call it National Guard. I mean, there was incredible resistance for generations to integration. And so I do think that and I don't know if I've seen polling from that time, but what I think the court did differently during that time is that they knew they want to make this decision, and they did it, I think, as Professor Berman said in her, the Nixon case, as well as the Brown case, they decided to do it unanimously, right? And they also decided, you know, a lot of people criticize Brown because it was slow, all deliberate speed, right? So not only did they do it unanimously, but they also knew they were going to go slowly. Some would say too slowly, but they went slowly. So I do think that's maybe the difference between then and now. Yeah, we didn't have social media, we didn't have memes, but we certainly had TV, and there was, you know, all these, you know, broadcasts about all these little black kids who were, you know, accosted by whites trying to go to school in the South. So I think that's probably equivalent to what we have, you know, to have now probably. But let's see if there's, let me see if we get another question for you before, because we have like 4 minutes. So this one asks about Section 3 and 5 of the 14th Amendment and whether it's regard. So if you served on the court as an anonymous attendee, how would you interpret Section 3 and 5 of the 14th Amendment, whether it is in regards to Trump, any other future federal official? So Professor Berman, what do you think about that?
I think I've always known that I never want to be a judge because these questions are really hard. I mean, so I think that there's sort of two ways to look at that decision. One is sort of, do you just put your head down and look at the text and decide the case? Or do you recognize the context in which you're making the decision and maybe accommodate that? And I think if you just go for the, you know, the text of the decision, I think there's a strong argument that President Trump would be disqualified. Of course, it all depends on how you define insurrection and giving aid and comfort and all that. But I think there's a strong argument. At the same time, do I think it would be a good idea for the court to declare a presidential candidate ineligible? No, I think that would be a horrible idea. And I think the court knew that and they found a way to not have to do it.
And the thing is that they may never have to do it because you need legislation now, right? And so how's that ever going to happen, right? So
maybe
you basically
we don't know.
Yeah, but you probably, you know, I mean, part of the thing is that what it seems to me with these immunity cases and that particular disqualification case, it seems like they've taken it all off the table. You know, that is, you know, that we'll probably never well, we've never done it before, right? Made someone a presidential candidate ineligible. And we're not likely to do it again because to get Congress to pass any legislation like that is like impossible, right? And then with the immunity cases, like, well, we have impeached presidents, but we've never convicted them. So that's off the, you know, is that, you know, in 200 and something years, we've never convicted a president. Now, maybe many of them didn't need to be convicted. Maybe some of them did need to be convicted, but we've never done it. It's a useless vessel for us because it's never happened. It requires 2/3 of the Senate to make it happen. And it's a political process, unlikely to happen. And as President Berman said, well, you know, people thought that the president could be prosecuted. I mean, that's why President Nixon took a pardon. You know, that's why he took a pardon. People thought he could be prosecuted. But it's, you know, with the immunity case, it really almost like they have created almost legislation, you know, to deal with this issue in a way that, as Professor Berman said, was not really asked for. But it makes it much harder for anybody to actually prosecute a former president or president criminally. All right, it's 5. Any last words from any of you?
Can't wait for next term.
Well, thank you. Thank you to our audience at home. And thank you to our all-star panel of fabulous UH Law Center faculty, Professor Berman, Professor Chandler, and Professor Salib.